Let's bring in NBC News legal analyst Danny Cevallos. Danny, obviously, this is just devastating, and we want to be clear with our viewers that no legal action that we know of has been taken. Ron did just read a late-breaking statement from OceanGate, them saying they sadly lost their CEO. Who could be liable here?
As a plaintiff's attorney, typically what you do is you look at anyone who may have had a hand in creating the liability, in being negligent or reckless or anything at all that may have contributed to this tragedy. And so part of being a plaintiff's attorney is investigating the case, not just going for the main person that you think might be liable, but looking beyond that to see who else may have been involved. So it's impossible to say, other than the owner and operator, who would be likely targets of a lawsuit. That really has to be determined, a strategic determination by plaintiff's counsel. But I have to tell you, one of the things that folks haven't really brought up yet, and they will be bringing up, is the admiralty laws that not only apply in the United States, but in Canada as well. And these date back to the 1800s, and they seriously limit liability for those in the shipping industry. As you can understand, at the time a lot of these laws were created, the shipping industry was something that was very, very essential. We didn't have airplanes yet, and so they had to be protected. And their liability can be really, really limited.
Interesting, especially given the variance in the seas.
Yeah. So former passengers have told NBC News that they've had to sign waivers in case their trip ultimately could lead to a death, and like this situation. So how could this all play into a potential lawsuit against OceanGate?
The default rule is that waivers will be enforced if they were signed knowingly. Now, the reality is we don't sign waivers knowingly. We sign them in a hurry because normally they're put in front of our face just before we get to go do the fun stuff. Whether or not that's something at an amusement park, going skiing, or, of course, getting on a giant submersible and going to the bottom of the ocean floor. We don't know anything about the circumstances under which any releases were signed or if releases were even actually signed or not. But I can tell you I've actually litigated and invalidated releases when they were signed under circumstances that were considered either too oppressive, too misleading, or even something as basic as the font size is too small. You can't put these releases in 8-point font throughout and pack them together at the end of a document. Some states forbid that, and even the size of the font can get a release invalidated.
And Danny, we know a former employee of OceanGate actually raised safety concerns prior, back in 2018. That was ultimately settled out of court. But what might this mean in this scenario that ended so fatally?
The key to negligence litigation is showing the difference between something that was completely unforeseeable that happened that was tragic and something that was foreseeable. And the way you show that something is foreseeable, which will lead to liability, is to show that there was prior notice. And the way to show there was prior notice is things like prior accidents, prior problems, prior complaints. All of those become incredibly relevant, and they're key to proving a case. You need to show that a defendant knew that there was a problem and failed to do something about it.
Time will tell, but I'm sure right now these families are just mourning, and we'll see what comes in the weeks ahead.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.